Oh yay, oh yay, oh yay! This Honorable Supreme Court of Tennessee is now in session. God save the United States of America, the state of Tennessee, and this honorable court. Please be seated.
Good morning. Welcome to this session of the Tennessee Supreme Court here in Clement Auditorium at Austin Peay State University. Our Scales project brings together judges, lawyers, and students to develop a better understanding of the judicial branch of government and the role of courts in our society. Unlike the cases you see on TV, today you're going to hear real cases with real lawyers representing real clients and real judges deciding the issues. We appreciate your participation as you're going to hear today. I want to thank Austin Peay State University and President Mike Licari, as well as the staff here at the university for hosting and helping coordinate this event. Special thanks to Judges Adrian Fry and Katie Olita of the 19th Judicial District, as well as the additional stakeholders who have worked hard to make this event possible. To the volunteer judges and lawyers, we appreciate your willingness to work closely with the students in preparation for today. Schools, we thank the administration, the teachers, and the students for your participation. We also want to recognize the Clarksville Police Department and the APSU Police Department who are providing us with security today. Thank you as well to the lawyers who are arguing their cases today. We recognize the extra effort for you to participate. I'm going to ask our newest Justice, Mary Wagner, to say a few words to the students today.
Good morning. I am so thankful to be here with you today and get to share a few moments about the judicial branch. As you hopefully know, our federal government operates with 3 branches of government. Hopefully you also know that the state of Tennessee operates very similarly. We have an executive branch, which in Tennessee is our governor, Governor Lee. We have the legislative branch, which is the Tennessee General Assembly. And then we have the 3rd branch, the judicial branch, which is us. The executive and legislative branches are more political. They adopt policy decisions, pass laws, oversee the state budget, and generally decide the direction of our state. We judges, however, are different. We don't make policy decisions or voice our personal opinions. That's why you will often not see judges in the media or in the news expressing comments on particular cases or laws or our personal opinions. Instead, we are tasked with upholding the Constitution of the United States and of Tennessee and the laws of the state of Tennessee. We do that through an adversarial system. It sounds like we sort of like to fight it out, and that's actually not true. But it means that we are resolving parties who have different positions or adverse positions on what the law is or the facts are or how a dispute should be resolved. We don't resolve hypothetical disputes or what you might call a what-if question. Through our court system, the parties will present their view of the facts and the laws to a neutral party to decide. Sometimes the ones making the decision at the trial level is the judge, and sometimes that is the jury, and the judge will play more of a referee type role. You will likely hear today about what happened at the trial court in this case. If someone is unhappy with what happens at a trial court, then they may appeal to the Court of Appeals or Court of Criminal Appeals. If they're still unhappy, then they may ask us to consider and review the case. Ultimately, our goal is to find the truth and uphold the law that is given to us by the other branches of government. You may have heard the phrase, "We are a nation of laws, not of men." That just means that we are all accountable to the same laws. It's not an arbitrary system or a system that is subject to one person or a group of people's whims or personal opinions. It's a system of government that we have chosen to live under, and the judicial branch is an integral part of that. So of course we can't serve that role without you. We need your support and confidence in the court system, and so we hope you'll stay involved and learn more about the judicial branch. Thank you. Chief Justice.
Thank you, Justice Wagner, for those wise words. We hope all of you will stay engaged with the judicial branch after today. You can follow us on Twitter at TNCourts, on our website, tncourts.gov, and on Facebook. The opinions we write on our website and to our Twitter feed. Now, I want to introduce to you the justices of the Tennessee Supreme Court. I'll introduce them according to their seniority. First is Justice Jeff Bivens, to my immediate right. He is a past Chief Justice of the Court, State University with a major in political science and a graduate of Vanderbilt University School of Law. He practiced law in Nashville and served as Assistant Commissioner and General Counsel for the Tennessee Department of Personnel. He has served as a trial court judge and a judge on the Court of Criminal Appeals. He's been a justice on this court since 2014. Justice Bivens lives in Franklin. Justice Sarah Campbell, to my immediate left, earned her bachelor's degree from the University of Tennessee at Knoxville and a master's degree and her Juris Doctorate, both from Duke University, in the same year. She served as law clerk to Justice Samuel Alito on the United States Supreme Court. Prior to her appointment to the Tennessee Supreme Court, she was Associate Solicitor General and Special Assistant to the Attorney General in the Tennessee Attorney General's office. Justice Tarwater, to my far right. Justice Tarwater earned his bachelor's degree and his law degree from the University of Tennessee at Knoxville. He served as general counsel to former Governor Bill Haslam for 6 years. Justice Tarwater was a litigator who managed hundreds of cases in federal and state courts at the trial and appellate levels and was recognized nationally for his skills. Justice Tarwater lives in Knoxville. Justice Mary Wagner, whom you heard earlier, is the newest member of our court. She's a graduate of the University of Colorado and the University of Memphis. She practiced law in Memphis before being appointed as a circuit court judge, a trial judge, and she was elected twice as circuit court judge in the Shelby County area. She was appointed to the Supreme Court in 2024, earlier this year. Justice Wagner lives in Shelby County. I am Chief Justice Holly Kirby. I graduated from the University of Memphis with a degree in engineering and from the University of Memphis School of Law. I clerked for a federal appellate judge and then practiced law in Memphis. I served on the Court of Appeals for 19 years before being appointed to the Supreme Court in 2014. So as you can see, we're from Tennessee and we went to different law schools. We all consider it a great privilege to serve on the highest court of our state. And we're committed to upholding the Constitution, protecting individual rights, and applying the laws of Tennessee. Now we're ready to get to work. Jim Hibner, our appellate court clerk, will now call our case.
State of Tennessee versus Ambreia, Washington.
Chief Justice Kirby, members of the court, good morning. May it please the court, my name is Brennan Wingirter. I'm here on behalf of the appellant, Mr. Ambreia, Washington, and I've requested to reserve 7 minutes of rebuttal with the honorable clerk. Your Honors, this case is about striking an appropriate balance between reasonable, legitimate law enforcement actions and the individual constitutional rights of the citizens of Tennessee. Considering the scope and interplay of the Second, Fourth, and Fifth Amendments at issue in this case, we've asked the court to reverse and vacate Mr. Washington's convictions for unlawful possession of a firearm, primarily because the arresting officer seized a handgun from Mr. Washington's car without giving Miranda warnings, without getting a warrant, and without establishing any exception to the warrant requirement. Now, as this court knows, Typically, when we analyze searches and seizures involving vehicles and their occupants, we start with the initial police-citizen encounter and then move chronologically through from a homeowner to the local police department. But there was a vehicle in her front yard. It was about 3 o'clock in the morning, and she was unsure whether the car had struck her mailbox, whether it was in the road, and she requested police assistance. Officer Keller of the Jackson Police Department responded to that dispatch. He arrived at the scene, and when he initially pulled his patrol car up to the location, he observed a vehicle parked on the wrong side of the road. He described it as about 50-50 in the homeowner's yard and in the road. He parked his patrol car. He got out. He did not activate his blue lights or his sirens, but he did turn the spotlight on his patrol vehicle onto this other car. Officer Keller approached that car. He had to that point, we have no problem with constitutionally. The trial court and the Court of Criminal Appeals both described Officer Keller's actions up to that point, the approach to the vehicle, as within his community caretaking function. We don't think community caretaking even needs to apply here because he's just responding to that dispatch call. It's an appropriate police response. He walks up to the car, tells Mr. Washington to stay in the vehicle. But as Officer Keller nears the car, he sees what he believes to be a handgun sitting in the front passenger seat. So as Mr. Washington is sort of awaking and getting out of the car, Officer Keller says, okay, go ahead and get on out, because he sees what he believes is this handgun. That's sort of the point, I think, where the interaction shifts into a criminal investigation. Officer Keller does not ask Mr. Washington, are you okay? Are you hurt? Did you hit this mailbox? What happened? His first question is, are you a convicted felon? Mr. Washington replies,
Before we move any further into the facts. Now, you say that at that point, that's when the officers kind of purpose shifted from perhaps community caretaking to criminal investigation. For purposes of our analysis of the various doctrines that are potentially implicated in this case, are we to examine the officer's subjective motivation? In other words, what was the officer's purpose for kind of doing what he did, or are we to look at all of the objective circumstances and to ask whether those circumstances, what those circumstances would justify for a reasonable officer? So is it subjective or is it objective?
Justice Campbell, I think it depends on which legal framework the court analyzes this under. And I say that primarily because, unfortunately, we don't have a very well-developed record on Officer Keller's, what he testified to at the suppression hearing, which was that when he saw that gun on the front passenger seat, he knew that, and he asked if Mr. Washington was a convicted felon. He knew right then and there that Mr. Washington was not free to leave and that he was detaining him for the purpose of confirming his felony status. That was Officer Keller's testimony. That's about all that we have from his subjective viewpoint at that time. I think whether it's objective or subjective depends on whether we are talking about the Fifth Amendment or the Fourth Amendment, and whether we are talking about plain view, one of the federal safety-related exceptions, the inevitable discovery doctrine. There's various points along the way that I think that might shift, which is why I want to be very clear with the court that I think we are missing a lot of facts, objectively and subjectively, to be able to apply really anything other than probably plain view and inevitable discovery. I think that's about all that is in the record that is sufficient to analyze under those frameworks.
So along those lines, is it your position that Mr. Washington was in custody at the time that Officer Keller asked if he was a convicted felon?
Yes, Your Honor, and that is what the trial court found. What's a little bit odd, to be candid with the court, is the motion to suppress that Mr. Washington filed in the trial court. He moved to suppress both his statement, his response that he was a convicted felon, and the handgun itself. That motion was based on the Fourth Amendment.
There be that show that the defendant would have perceived that he was in custody.
Yes, Your Honor. Before I answer, if I may clarify, I don't believe the state has ever challenged the trial court's ruling that he was in custody, that there was a Miranda violation. But if this court wanted to get there.
Well, you are hinging your argument on the fact that he was not read his Miranda rights at that point. So I think we have to assume that we'll have to look at that.
Yes, Your Honor. So when Officer Keller approached, although his lights and sirens were not activated, he did have the spotlight on Mr. Washington's car. And the first thing he mentioned to Mr. Washington, first to stay in the car and then to step out of the car. As soon as Mr. Washington starts exiting the car, unfortunately, Officer Keller's body camera did not turn on until he already has Mr. Washington pinned against the back of the car and is trying to handcuff him. So in those brief seconds beforehand, I think all we have is Officer Keller's testimony. Even from an objective standpoint, he's approached the car, he's ordered Mr. Washington out of the car, immediately asked him a question that is going to elicit this incriminating.
So all the objective circumstances, apart from whatever the officer's interior thoughts were, all that we have is that the officer approached with a light and said, as Mr. Washington started to get out of the car, no, don't, oh, yeah, please, go ahead, maybe not please, but get out.
Yes, Your Honor.
And that's it? And is it your position that that is sufficient, that Mr. Washington would have perceived that he was in custody?
At that point, yes, Your Honor. And it's our position because, one, it is dark, and he has this flashlight shining straight in his face. It is an officer giving him a command. And again, almost immediately, the officer is asking him a question that implicates a investigation. And then again, this all happens so fast, but pretty much immediately.
Well, let me follow up on that point, counsel. Let's assume for a second, instead of a gun on the passenger seat, it was an unopened six-pack of beer. Said, have you been drinking tonight?
So the Tennessee Court of Criminal Appeals has actually addressed that exact question and has said that that is permissible.
I understand.
During a traffic stop.
That's my point.
Yes, Your Honor.
So why is there any difference in asking whether he's a felon or not versus not? Both of them can become inculpatory.
That's correct, Your Honor. I think in this case, though, the timing, the flashlight in his eyes, and I know we're looking at this from an objective standpoint, whether Mr. Washington felt free to leave, but I don't think we can ignore the fact that Officer Keller said at that point he was not free to leave, and I'm going to detain him at that point. And he did immediately have him pinned against the back of the car, Mr. Washington with his chest to the car and trying to put him in handcuffs.
But that was after the question and the answer.
That's correct, Your Honor, yes.
Well, oh, go ahead. I'm sorry. You can finish your response.
No, that's okay. It was after the question. I do think this all happened almost simultaneously.
As you point out, the state has never challenged that's custody determination. So let's just, I guess, assume for present purposes that decision was correct, and kind of move forward a little bit in the analysis to, whether the officer could rely on that unwarranted statement to inform the rest of his actions. Now, the state cites some precedents from the U.S. Supreme Court and our court, holding that a Miranda violation require the suppression of the non-testimonial fruits of an unwarranted statement.
That's correct.
Do you have any argument that actor here was not able to rely on even if the statement itself could not come into evidence at trial? Do you have any argument that the officer could not rely on that statement to inform his further actions, including his seizure of the firearm?
Yes, Your Honor, I have a couple of points to that. And number one, I think subjectively, and looking at what is in the record, the little bit that we do have in the record, Officer Keller did not think the statement alone was enough. Officer Keller got the answer and then said, I was detaining him for the purpose of confirming his felony status. So I don't think Officer Keller thought
But do his subjective motivations matter? Does his subjective intent matter?
In terms
When you
of
said it could vary depending on what framework we're within, what doctrine we're applying. So when we're point in time and whether the officer had kind of sufficient information to warrant his seizure of the weapon, does it matter why he was doing it?
I think it does,
and
I think his intent matters. But I think the timing is maybe perhaps more important. So Officer Keller didn't think the statement was enough. The Court of Criminal Appeals didn't apparently think the statement was enough because the Court of Criminal Appeals holding, a little bit different from the state's argument. The Court of Criminal Appeals said that the plain view exception applied to allow Officer Keller to seize the handgun once the criminal history check was completed, not once Mr. Washington said he was a felon, but once the criminal history check was completed.
Why wouldn't his statement be enough? I have trouble understanding that. I mean, he admitted without any caveats, without any qualification, that he's a convicted felon. Why isn't that enough?
So my answer to that, Your Honor, as I've been thinking about all the different legal standards at play here, I cannot speak to what Officer Keller was thinking, but from my perspective, that goes sort of to the Bruin line of cases, where just being a convicted felon by itself may or may not render the possession of a firearm unlawful anymore. I'm not saying that's what Officer Keller was doing, but I think if we look at it objectively, someone saying they're a convicted felon, after Bruin, and I know it's changing pretty rapidly in that area of the law, but simply possessing a firearm with a prior felony conviction on your record is not automatically necessarily going to be a criminal behavior. And the plain view exception requires that the illegality of the contraband, the handgun here, be immediately apparent. Now, the state's position...
But plain view has to do with the search. And there wasn't a search here. He just came up upon the car and saw it. The real issue is the seizure, right?
That's correct.
When do you say that the firearm was seized? At what point do you say?
So the firearm, from my understanding of the seeks, Mr. Washington, once Officer Keller attempted to detain him and he broke free, Mr. Washington was then tased and then was taken into custody. He's put in handcuffs, he's put in the back of a patrol car. Then it's my understanding that Officer Keller went back to the car, and there are some photographs in the record where Officer Keller is sort of leaning into the vehicle and he's holding the handgun and an ammunition clip in his other hand, and someone else is apparently taking a picture of that. So at that point, Officer Keller has seized the handgun. And
So
then
not until the officer physically touches the firearm are you saying that the seizure took place?
That's correct, Your Honor. And I think, again, that's why this timing is so important, in our view at least.
So at that point, though, he knew your client's statement that he was a convicted felon. Is there a dispute in the record about whether he had confirmed that fact before he actually touched the firearm?
That's actually a primary dispute and something I'd like to clarify for the court. In the briefs, the state has argued that so long as Officer Keller knew of Mr. Washington's felon status before he seized the gun, plain view exception applies and we're fine.
I mean, it's not what the officer knew when he saw.
Correct.
When he saw the firearm, it's what he knew when he
seized
touched it.
That's correct. And unfortunately, I wrote my brief under the mistaken impression that it was unclear from the record about when the criminal history check occurred and when the status was confirmed. In preparing for argument today, I discovered there is actually a finding in the trial court's written order. It's page 24 in the technical record. And the trial court finds in that written order that the criminal history check was not done until after Mr. Washington was transported to the jail. So this whole dispute about when this felony status, I agree with the state's arguments that the timing matters, and for plain view, it matters about what the officer knew before the handgun was seized. But we do have this confirmation in the record from the trial court's finding that the confirmation did not happen until later, which in my view then shifts us into inevitable discovery rather than plain view.
And before we move to that, though, I do want to clarify your position. It was my understanding that your argument for purposes of the plain view doctrine was that the illegality of the evidence had to be immediately apparent at the time of the discovery of the evidence. So applied here, that would mean that when the officer first saw the weapon laying on the seat of the car, that at that point in time, the unlawfulness of that firearm had to be immediately apparent at that very point in time, not at the time of seizure. Am I misunderstanding that, or is that your position?
No, Your Honor, but I think my position is sort of the inverse, where just seeing a firearm does not mean it's contraband, because you can lawfully possess.
No, I understand that, but what is the relevant point in time for the immediately apparent unlawfulness of the item? When does it have to be immediately apparent?
It has to be, I agree with the state that it has to be before the item is seized. And so then the question becomes, is the statement by itself enough to authorize the seizure, which is my point back to Officer Keller didn't think so, the Court of Criminal Appeals didn't think so. And I recognize that it's a Miranda violation and we're not talking about the fruits of the poisonous tree. But I do think that this case is different, and this sort of relates to plain view and inevitable discovery. We're not just talking about the Fifth Amendment, we're talking about the Second and the Fourth as well. And so that's why we have argued that if the court is looking at the timing before the seizure, which I think is appropriate, I think the state and I agree that that's the appropriate timing. The criminal history check had not been done. We know that definitively from the trial court's finding. And so all we have is the statement that was obtained in violation of Miranda.
Well, that's, that was an unequivocal statement by this defendant that he's a convicted felon. And I'm really having trouble understanding how that does not, give the officer circumstances under which it would be reasonable to think that this item is in the unlawful possession of this defendant.
I think it's perfectly sufficient to officer reason to do what he was about to do, which was to detain Mr. Washington briefly to further invest the handgun as contraband. I think perhaps because of the way his argument.
Maybe I'm missing it. But Justice Campbell has asked a couple of times, why isn't just his statement, his verbal statement, yes, I'm a convicted felon? Why isn't that enough to justify the seizure without a warrant? I mean, all that was not apparent when he saw it, but for our purposes, that doesn't make a whole lot of difference. What's pertinent is what the officer knew when he seized it, and there's no question but that he had heard the defendant's statement. So why is that not enough?
You're correct, Your Honor, and I think the reason it's not enough, the way that we have framed the argument, is in light of Bruin and Bruin's progeny, is even saying you're a convicted felon, but if it was for some nonviolent prior crime, perhaps might not be.
Let me ask it this. Okay, so there is a statute. There is a Tennessee statute that makes it a crime for a convicted felon to possess a handgun, correct?
Correct.
Okay, is there any binding precedent, any precedent that binds this court squarely holding that it violates the Second Amendment to make it a crime for a convicted felon to possess a firearm?
Not in this court, Your Honor. That is correct.
Okay, so then why would it not have been immediately apparent to the officer, based on the defendant's statement that he was a convicted felon, that his possession of the firearm was unlawful?
I think because it's an un-Mirandized statement, so we go back to the Fifth Amendment violation.
Well, but I already asked you, though, about why, whether you have any response to the state's argument that, we have precedents holding that a mere Miranda violation does not prevent officers from relying on that statement for probable cause for an arrest or for probable cause to seize evidence. So and I haven't really heard your response to that. So if that's true, that Miranda does not bar the use of the non-testimonial fruits of an unwarned statement, then why does the Miranda violation even matter here for purposes of the plain view analysis?
Because I think that is generally true. In our position, and I recognize that this is not, does not come up very frequently in this context, because typically when we're talking about Miranda violations and the exclusionary rule and what gets suppressed, we're talking about that the actual coercion, police interrogation, where they're actually coercing statements in a different setting. So I understand this is a little bit different. But our position is that the purpose of the exclusionary rule is to protect individual constitutional rights. And here, it's not merely a Miranda violation. We're talking about the Second Amendment, the Fourth, and the Fifth. All of those were at play at the trial court level and in this court now. And so our position is not, court, ignore all the precedent that the state has cited that generally we don't suppress the fruits of the poisonous tree for a Miranda violation. But in this particular case, under the purpose of the exclusionary rule, this is one of those times when that purpose...
Are you asking for an extension?
I don't believe so. I don't believe so, Your Honor, because I'm not asking this court to change the Miranda law. I'm just asking the court to look at this not as merely a Fifth Amendment violation, but as the Fourth, the Second, and the Fifth all together. And I understand it's more of a policy argument, but we're talking about, as I said at the beginning, balancing this reasonable, legitimate law enforcement action against these individual constitutional rights. And it is more than just one. So what we're asking the court is to look at how this unfolded, the timing, the progression. And again, I'll go back to the timing of confirming the criminal history check, the status, not occurring until after they're back at the station.
I'm sorry, go ahead.
No,
Finish
I was just going to say,
thought.
all the case law is clear that if the felony status, the criminal history check was done on site that night, I don't have an argument. I absolutely would concede that, but that's not the case that we have here.
Yes, I want to clarify a little bit about your Second Amendment argument here, because this event took place around 3:20 a.m. on November the 6th, 2020, correct?
That's correct. That's correct.
Bruin was not decided until 2022, correct?
That's correct, Your Honor.
So Bruin would have had no
would not have
impact on
been-
the officer at that
That's
point.
correct. Yes, yes. I apologize. I didn't mean to imply otherwise. I see that my time is up. If there are...
Ms. Winger, with the Chief Justice's permission, I do have a question about your position on why the inevitable discovery doctrine wouldn't apply. Obviously, a criminal background check's going to be done, and it's going to turn up the conviction. So why is that not determinative of the issue in this case?
That's correct. I actually do think the inevitable discovery doctrine is the more legally sound way for the court to rule among all the options. My response to that, though, is for the inevitable discovery doctrine to apply, it's the state's burden to show that they would have not just discovered the felony status, the criminal history, but that they would have seized the gun. And in our reply brief, I laid out several other options that Officer Keller could have done that night that would have safely secured the firearm there at the scene without seizing it without a warrant at that point.
But the doctrine in and of itself would apply to statements, correct? It doesn't, we shouldn't treat the statement any different, tangible evidence of the handgun in application of the inevitable discovery doctrine, should we?
I think then it depends if we're talking about Fourth Amendment or Fifth Amendment, to be candid with the court. If we're talking about Fourth Amendment, then absolutely the handgun is it squarely at issue. With the Fifth Amendment, I admit it is a more of a policy argument that we made in the reply brief.
Thank you, counsel.
Thank you, Your Honors.
Good morning, Your Honors, and may it please the Court. Matt Cloutier on behalf of the state. There are three clear paths to affirm in this case: plain view, officer and public safety, and inevitable discovery. But before I delve into those paths, I do want to address, I think, what is the more fundamental issue in this case. At every stage, really until today, Washington has framed this primarily as a Fourth Amendment case, but he has yet to identify a Fourth Amendment violation. He concedes, for example, that Officer Keller permissibly saw the gun, so we know there was no search. And he doesn't dispute that if Officer Keller was permissibly aware of Washington's felony record, he could seize the gun. So I think the only question that really matters in this case is whether the way that he found out about those felony convictions poses any constitutional problem. And because he found out by asking a question, not by conducting a search, we need to be looking at the Fifth Amendment, not the Fourth. And under the Fifth Amendment, as we've explained in our briefing, we think this is an easy case. This court and the United States Supreme Court have held that neither that amendment nor its Tennessee counterpart are violated when an officer fails to provide Miranda warnings. Instead, these provisions are violated only by the admission of an unwarned statement at trial. Those courts have also made clear that these constitutional provisions do not require the suppression of physical evidence, as Your Honors just noted. Instead, the suppression of the statement is a complete and sufficient remedy. So I think the takeaway here is that the courts below, regardless of how they phrased their reasoning, got the conclusion exactly right. They suppressed Washington's statement, but they admitted the gun, and we would ask that this court affirm. Now, if I can, I'd like to start with the plain view doctrine, because I tend to think that is actually the clearest way to resolve this case, because again, I think to dispose of the Miranda violation, we're dealing with a straightforward plain view analysis where we just apply the traditional three factors. And because Officer Keller knew at the time that he seized the gun, which I think my opposing counsel concedes is the proper time to consider, as soon as he had that information about Washington's felony record, he could permissibly seize the gun, and that's exactly what he did. So I think we would ask this court to conduct a traditional, straightforward, plain view analysis, walking through the three factors, which I'm happy to do.
Mr. Cloutier, if I could interrupt you there, can you point to any precedent in which an unwarned statement, a court has allowed an officer to rely on an unwarned statement to as the basis for the kind of immediately apparent unlawfulness of an item that would justify seizing the item under the plain view doctrine? I know there are precedents involving, relying on an unwarned statement as probable arrest. The U.S. Supreme Court precedent that you saw in that case, I think the defendant actually gave permission for the seizure of the item, so that wasn't a plain view case. Are you aware of any precedent sort of applying this, the notion that a Miranda violation doesn't bar the use of the non-testimonial fruits in the context of a plain view
I'm not, Your Honor. I don't think
is there any reason to treat that differently?
I certainly don't think there's a reason to treat it differently. I think I'd point this court to the general rule that it articulated earlier this year in State v. Green, which is that responses to police questioning are a common source of probable cause determinations. And to the extent that we're dealing with a warning or a lack of a warning, again, that's governed by the Fifth Amendment. It's important to keep those analytically distinct when engaging in this kind of analysis. As for why, we didn't encounter any cases where this exact scenario came up, I mean, my candid assumption is that it's because it's usually a non-issue. I think, cases like the one that Justice Bivens posited where, for example, you see a six-pack of beer in the car and you ask about that without providing Miranda warnings. Again, I think everybody assumes, rightfully so, that the officer has the ability and needs the ability to act on what they, see, perceive, and hear from the defendant in the course of those interactions. So again, I really don't think the kind of Fifth Amendment angle here does anything to alter the traditional, straightforward, plain view analysis. So I apologize, I don't have any case law, but I think just conceptually that has to be the rule for this.
And you're not aware of any precedent holding that it can't be applied?
Certainly not, Your Honor. And I think that again aligns with kind of the broader purposes of the Fourth and Fifth Amendments and their respective different remedies. If the court wants to take me elsewhere, I'm happy to walk through the various plain view factors and explain why we think they're satisfied, though I'll note at the outset that I think everybody here agrees that the first requirement is fully satisfied, both because, Officer Keller, as I understood my friend on the other side to agree, didn't violate the Constitution in simply approaching Washington's car in the first place, but then we, of course, have the community caretaking doctrine as a backstop that justifies his initial kind of intervention to make sure that Washington was okay and able to safely drive on the roads. So I think the second factor is the one that we spent more time on in our brief, or second element, I apologize, and that requires that Officer Keller be aware of the handgun's illegality when he seized it. But again, I think my friend on the other side now agrees that the relevant time is in fact the time of the seizure, not the time of the first observation. Or that element is clearly satisfied here as well.
Let me push you on that a little bit. You're saying that it's the point of seizure, but what's the limit to your position there? I mean, you can imagine a situation where a pretty significant length of time, transpires between the initial viewing of the evidence and seizure, and that, pretty significant efforts had to be undertaken in that course of time to actually discover that this item is unlawful, consulting with third parties, examining the idea. It's a weapon that it's hard to tell whether it's semi-automatic or automatic, or, there could be a variety of kind of a gray area where you're not sure upon immediate observation. So is there what an officer can do between the point of discovery and seizure that would make it unfair, I guess, to apply the plain view doctrine in that situation?
There is, Your Honor. I think the kind of cleanest limit or most obvious limit would be some additional Fourth Amendment intrusion. So the name of the case escapes me at the moment, but a U.S. Supreme Court case dealing with the plain view doctrine where officers came into a house, I believe pursuant to a search warrant, and saw stereo equipment. Mm-hmm. They could jot down the serial numbers that were visible and use that to determine whether or not those items were stolen. But what they couldn't do,
pick it up and
exactly,
inspect
Your
it.
Honor, because again, that is an additional Fourth Amendment intrusion. So I think here, if we envision a different slate of facts where Officer Keller approached the car, again, permissive as everybody agrees, but had to conduct some additional Fourth Amendment intrusion to see the gun, for instance.
What about consulting? I mean, what if you didn't have to pick the gun up, but maybe you had to independently and provide an assessment about whether it was unlawful or not?
Would
think
that
if
be
that
okay?
happened, I think if it happened quickly within the context of the kind of permissible law enforcement interaction, that might be permissible. I think the challenge, and this comes up usually in a case where officers are conducting a search pursuant to a warrant of a home or something like that. I think that's where you more often see these longer duration kind of situations in the plain view context. And I think, we cited some federal cases in our brief where, for instance, an officer saw, I believe it was drug paraphernalia, back upstairs, kind of continued to search under the warrant, and then went back downstairs, and it was at that point that they determined that it was illegal and chose to seize it. I think there's another situation where in the course of conducting a search, they found a key to a car that was in the driveway, and only at that point did they go back and use it to open the car and confirm that it was kind of used in a crime. I think all of those happened within sort of the context of this already authorized search. So I think as long as it's temporally tied to the existing Fourth Amendment intrusion, we tend to think that would probably be fine. But obviously, we think this is a much easier case than any of those situations.
So can you clarify the record for us on when the officer confirmed confirmed the defendant's statement that he was a convicted felon? It sounded like your brief was premised on the confirmation having taken place before the seizure. Is that correct? Is it not correct?
A few points in response to that, Your Honor. I think the first we would say is that, yes, in our brief, we relied on Officer Keller's testimony, which I did read to suggest that he performed the records check while still on the scene. I think that's the position we took. But of course, that was a backup argument. We think that the admission was the kind of proper and initial source of his ability to kind of have probable cause to seize the gun. So we don't think it's necessary for us to. The second point, though, I guess, is that, to the extent it came up differently, or I suppose if there's any discrepancy in the testimony, or if the testimony isn't as clear as might be ideal, obviously the state, as the prevailing party in the motion to suppress context, gets the benefit of all reasonable inferences that can be drawn from that testimony. And, I struggle to see how Officer Keller's testimony could be read to suggest that he performed the record check back at the station, for instance. Obviously, if that's what the trial court concluded and we haven't contested that, then I think basically our bottom line position is that Washington's admission was the true source of probable cause in this case. And if I can, I actually do want to touch on that a little bit, because my friend on the other side suggested that admission gave Officer Keller the impetus to confirm his felony status before any sort of additional seizure. I think my frontline response is I'm not sure that's how I read it. I understood him to be taking Washington into custody as soon as that admission was given. But beyond that, I think to Justice Campbell's questions, we do think probable cause is necessarily an objective inquiry. And that statement, as I referenced earlier, per this court's decision in State v. Green, can easily be a source of a probable cause determination. And I think Washington's briefing, too, also kind of bears this out, because as I understood him, he appears to concede that if he had stepped out of the car and volunteered, with no question at all that he had a felony conviction, there probably wouldn't be a Fourth or Fifth Amendment problem here. So, I don't see how a purely voluntary admission would create probable cause to arrest and seize the gun. And again, I think to the extent there is any concern about the question, the proper place to look for, whether that breaches any constitutional line is the Fifth Amendment and not the Fourth. So a final plain view requirement, which I don't take to be particularly contested here, but it's the requirement that Officer Keller had a lawful right of access to the handgun. And obviously, I think we've relied on the automobile exception here. And again, I don't understand my friend on the other side to take a different view of this. But so long as Officer Keller did have probable cause to believe that the gun was contraband or unlawfully possessed, which he again did, I think it's at the end amendment issues that have been lurking throughout. And if the court doesn't have any further plain view questions, I'm happy to discuss the various doctrines raised in the court's grant order, but I do think that the plain view doctrine is the cleanest way to resolve this case.
May I ask this question, General, under the plain view doctrine? The case suppressed the defendant's statement.
But here, when we're dealing with kind of a two-element crime, which is felony convictions and possession of the gun, I don't think we need the statement, because we have his the records of his felony convictions that were introduced at trial, and in the transcript, Washington's trial level attorney agreed and did not dispute that he had felony convictions.
What if the statement had actually been coerced, so it wasn't just that the statement was unwarned, Miranda warning, but that it was, in fact, a coerced response? Would your answer be different?
It would, Your Honor. I think we would agree, as this court obviously said, and I think Clymer and maybe Walton as well, that a truly coerced statement is actually a violation of the Fifth and exclusion of that statement. But I think that really gets at why there's no problem here, because again, when you simply have a failure to provide Miranda warnings, which I'll note that the U.S. Supreme Court in Patain said that doesn't even violate Miranda itself, let alone the Fifth Amendment. I'm not sure that this court has gone quite that far, but it has certainly said that it's not a Fifth Amendment violation. Tennessee's analog to the Fifth Amendment or same exclusionary rule in that context.
Do you concede that the defendant was in custody when he made that statement, or are you just assuming that for purposes of argument?
We're assuming that for purposes of the argument. I think we kind of took the case as we found it. That wasn't contested below, and the trial court seemed to conclude that he was in custody for Miranda purposes. I think if this court wanted to disagree and take a different tack here, we certainly wouldn't, dissuade the court from doing that. But, for the reasons we've discussed, we don't think the court has to do that. We think even if he was in custody and even if he was entitled to Miranda warnings, the suppression of his unworn statement fully remedies any kind of potential violation in that context.
Did the state argue below that the firearm was properly seized because of, officer or public safety concerns or pursuant to the inevitable discovery doctrine? Were those arguments presented by the state at all?
They were not. We raised those for the first time in response to this court's grant order. We do think that those provide avenues for the seizure and admission of the gun, but again, I think they require a bit more work. In the first kind of response to the first question in the court's grant order, obviously adopting these kind of safety-related exceptions that are not yet present in Tennessee law does require some expansion and kind of reliance on federal law to craft a new exception, which I know the court has been kind of reticent to do in the past. I think there is a basis for the court to do so here if it wants to, but it's, I think, a little harder to justify when we have another cleaner avenue under existing law. And I think when it comes to the inevitable discovery doctrine, I think that can also cut in our favor. I think the Sixth Circuit's decision in Frederick, which was cited in the grant order, I think provides a helpful kind of Circuit's decision in Frederick, which was cited in the grant order, I think provides a helpful kind of common sense roadmap for how that doctrine could apply in a case like that. He's contesting that Officer Keller permissibly saw the gun. I think everybody's on the same page there. And it's hard to envision, I think, any scenario in which Officer Keller arrives on the scene, again, at 3 in the morning, sees the defendant asleep in the front seat, a gun on the passenger seat, and then leaves the scene without conducting any sort of record check or otherwise determining that this individual had felony convictions.
So often in inevitable discovery cases, the law enforcement agencies' standard procedures, what it ordinarily would do in a certain situation, which provide evidence along those lines here about what would the officers or the kind of law enforcement agencies' ordinary protocol have been in this situation?
That there isn't much. Officer Keller testified, I believe, that when he ran him for the records check, he would have found out he was a felon. It's not entirely clear that he was intending to signal that he would have done that at the scene regardless, but I think that is one way to read it. So I think that would be evidence that his usual process would have resulted in the disclosure of this felon status information. But I think the broader point, and this gets at, I guess, why when the initial discovery or initial seizure was unlawful, but then is lawful on its own. But here we have one seizure and one discovery. We don't have a Fourth Amendment violation at all, as we've argued, because no search. He saw the gun in plain view after he knew about the felony conviction, justify with a later lawful action. So I think, again, Frederick does give some help in that I think it takes a slightly less rigid approach to application of the doctrine. But once again, I really don't think the court has to get this far to rule in the state's favor here. I think the plain view doctrine does all the work we need it to do. And if the court has no more questions, I'm happy to conclude. And I think, if I can leave the court with a final thought, it's again, I guess what I've been saying several times here, but I think it's that a straightforward application of existing Fourth and Fifth Amendment is enough to resolve this case. Starting with the Fourth, again, Officer Keller permissibly seized the handgun under the plain view exception. He didn't violate the Fourth Amendment in approaching Washington's car. The incriminating nature of the handgun was apparent at the time he seized it, and he had a lawful right of access to the handgun at the time of the seizure. And then turning to the Fifth Amendment, Officer Keller's question did not violate Washington's Fifth Amendment rights or, per the U.S. Supreme Court's decision in Patain, even Miranda itself. So any potential Miranda violation here was completely remedied by the suppression of Washington's statement, and there's no way in which the gun needed to be suppressed. So for all of these reasons, we'd ask this court to affirm. Thank you.
Thank you, counsel.
Just briefly on rebuttal, Your Honor. Number one, I heard my side say that the lower courts reached the right conclusion regardless of the analysis. At the risk of sounding too much like the argument before us, I would like to clarify that the reason we filed the Rule 11 application to this court was to correct that analysis under the plain view exception and the community caretaking doctrine. So the Court of Criminal Exception applied because the illegality of the handgun became apparent once the criminal history check occurred, which we know did not happen before the seizure occurred. So we thought that that was wrong. On the community caretaking doctrine, the Court of Criminal Appeals said that that applied, and it extended even to allow Officer Keller to make an investigation, which we think is wrong because community caretaking has to be totally divorced. So that was really the purpose of sure that the Court of Criminal Appeals analysis did not become precedential value.
Your point is really that community caretaking doesn't apply here at all. The officer was responding to a call for the police to investigate an accident.
Yes, Chief Justice Kirby, absolutely. And then as to plain view, if this court affirms on the basis of plain view, I think that the only legitimate way to do that is, as Justice Campbell was indicating, is to hold that the statement itself, even though unwarned, even though it violated Miranda, is enough. I don't think it is fair to go so far as to say the criminal history check occurred on site and that was good enough, because I think that's contrary to the record. So I just want to be clear with the court. We were trying to correct both points of the analysis by the courts below when we filed the Rule 11 application. I didn't hear the state really argue for application of either of those federal safety-related exceptions. I do feel like we adequately briefed that, but if I may just a few points on that. When this court has adopted such exceptions in other cases, typically it is when the state urges the court to do so, it is squarely presented, and we do have a better factual record. And here, as I think I heard the state acknowledge, we just don't have enough to was not argued below. So we would, again, ask the court.
Counsel, let me ask one question for clarification purposes, too. I understood you in your initial argument to agree that the relevant, whether immediately apparent for purposes of the plain view doctrine is the time of the seizure.
Correct, Your Honor.
Okay.
It has to be before the seizure occurs.
It has to be at some point before the seizure.
Yes, Your Honor. I do acknowledge the state's position, and I think the state is correct in the case law cited that it doesn't have to be the moment the officer sees it. But to your point, Justice Campbell, we can't have this extended adventure by law enforcement. Again, we're balancing legitimate law enforcement actions and individual constitutional rights.
But he also then would not have had to have been immediately apparent to him when he first made the stop.
When he first walked up, correct,
Yes.
Your Honor? Yes, exactly. It's our position that he did have to do the criminal history check on site. That Shine case is I think, is most on point with the timing of when that occurred. But if the court disagrees and ends up ruling that the state self is enough despite the Miranda violation, I do agree with the state. That is straightforward Fifth Amendment, Fourth Amendment law, and we don't need to get into these other doctrines.
Would you agree with the state's proposed limits on this, immediately apparent unlawfulness framework that, that the state suggested that perhaps one limit could be that there can't be kind of an additional Fourth Amendment intrusion, gave the example of the case involving the stereo equipment where it was sort of picked up and inspected thoroughly. Do you agree with that? Would you propose any other limits that prevent this from gates for officers to seize evidence in the absence of a warrant?
Yes, Your Honor, I absolutely agree with that. And I think if in this scenario, if I were to propose a limit, it would be do the criminal history check, confirm the felony status before doing the seizure. If the court disagrees, I respect that, of course. But our position is that that's a simple call to dispatch. It could have been done. I know other things were going on maybe at the scene that sort of maybe it slipped the officer's mind. But our point is when we're talking about reasonable, legitimate police behavior, if it is protocol to do that criminal history check, I think we all sort of assumed it could have and should have and normally would have occurred on scene, that's what should have happened here. It's what Officer Keller was going to do.
I'm still having some trouble understanding why that would be necessary, especially if we set aside your Second Amendment argument. I'm still struggling to understand your position there about why that additional step was necessary to make the unlawfulness of the weapon immediately apparent. Do you have anything to add in that regard?
Not other than to maybe reiterate what I've said, is that just him saying it under those circumstances, I don't think Officer Keller thought it was enough. I don't think the Court of Criminal Appeals thought it enough, and we would argue it is not enough by itself. It's reasonable suspicion to detain and continue investigating, which is what Officer Keller was going to do. I would disagree with my friend about he was putting him in custody right there. I think Officer Keller's testimony from the suppression hearing was he was not free to leave. I was detaining him to confirm his felony status, and then sort of everything else happened after that. So we do think that that should have happened before they seized the handgun. We would ask the court to reverse and vacate the convictions for unlawful possession. Thank you, Your Honors.
Thank you, counsel. Interesting case and fine arguments. We appreciate you both. The case will be submitted.
All rise. This honorable court is now adjourned. Y'all want to just take a seat?